In other news tonight, the Judicial Court Tribunal that's looking into sexual harassment allegations against Eastern Cape Judge President Mbenenge has heard how power imbalances in the workplace could create difficulties and consequences if the victim turns down inappropriate advances. The landmark investigation is looking at a complaint by a judge's secretary, Andy Somengo, who says that she was sexually harassed in the form of in-person interactions and via cell phone communication between 2021 and November 2022, allegedly by Judge Mbenenge. Today's witness, Lisa Vetten, who's a researcher in the field of violence against women, has been guiding the tribunal through nuances surrounding sexual harassment in the workplace, which include that very issue of power imbalance as well as submission versus consent. This as the tribunal has heard that the interactions between the judge and Mengo involved that power imbalance of a superior speaking to a member of staff rather inappropriately.
Saying no to somebody who is your senior is difficult. Firstly, it is an inversion of the relationship as to who says, who directs or instructs, and who follows instructions. So for a junior person to tell a senior person, it can be a very difficult thing to do precisely because there is that inversion. The other thing is, what are the consequences of me saying no to somebody who holds a higher position in the hierarchy than I do? If I say no, I am their junior, will they take me seriously? And what are the consequences? Can this person victimize me? Can they make my work uncomfortable? Can they ask me to go and start doing work that I don't want to do? Can they start taking away workplace opportunities from me? Can they start speaking to me in a way that is extremely uncomfortable and makes my work miserable? So this is where it starts to get uncomfortable because you now have not just the operation of the informal social relationship of gender, but you now have a structured relationship upheld by law that sets out this is how you will relate to each other, this is a workplace, this is who says this and who does that. So that is why it becomes very difficult.
Let's take that further now. Bring in Judges Matters Coordinator Alison Tilley. Alison, a very good evening to you. Welcome back to SABC News. So, Advocate Sikakane appearing on behalf of Judge Mbenenge, trying to paint a picture of Lisa Vetten as a biased and perhaps unreliable expert in this matter. Did she appear fair and did he succeed?
Well, I think they focused on the evidence, which I think is obviously the right place to be. And I think his questioning was really trying to suggest that she was biased. And I think in the last exchanges, looking at what evidence she had cited and whether the papers that she had put down as indicating being in favor of her view, saying, well, that they could have been perhaps taking a different view. But I would say thus far, she has given the evidence, I think, that one would expect around sexual harassment and, you know, the sort of how it operates. And I wouldn't say that any of that evidence has been shaken thus far. We obviously still have more time for Advocate Sikakane to cross-examine her. So, but she's also made the concessions, I think, that other explanations of the conduct are possible, that her view is not the only possible view of the facts thus far. So I think she has also correctly made concessions.
And in terms of the legal test that the tribunal is dealing with here in determining whether indeed the judge is guilty of misconduct in the form of sexual harassment of a junior member, not a junior member of staff necessarily, but a subordinate, Why is it not enough that Ms. Mengo says she did say on more than one occasion to the judge that she did not want to continue with this line of conversation? Does the fact that she may have, in some instances, deflected or even played along necessarily mean that there's no credibility to what she's saying legally?
No, and I think that's exactly where the questioning is at the moment. If she said things other than no, what did that mean? And I think that's where Ms. Vetten's evidence is going at the moment. And what do we understand from the fact that she did not necessarily say no repeatedly, but said no in amongst other communication? I think what we have to remember is that ultimately this is not a test about sexual harassment, but a test around judicial conduct and a judge acting honourably at all times, and the various other standards that are set out in the code of conduct. Mm-hmm. And I think that's really where it might be misdirecting ourselves to look perhaps in too much detail as to whether it meets the test for sexual harassment or not.
And let's perhaps, Alison, just apologies, let's draw that distinction that you're trying to make here in terms of whether indeed the judge was guilty of sexual harassment versus a finding of misconduct. Would he, for instance, quite plainly, if he's not committed sexual harassment, does that mean he walks, for example, on the charge of misconduct?
Well, I think that's exactly where I'm pointing, is that the fact that he had that relationship with a junior staffer, even if it did not involve any sexual harassment and was consensual, I think we would have to ask the question whether that was a judge acting always, and not only in the discharge of his official duties, acting honourably and in a manner befitting judicial office. So I think that's really the one of the questions that we're going to be asking. Also a question around avoiding treating people in a way that is unequal, treating them without the due regard to their right to equality. So I think it's certainly a very interesting question as to exactly where and when you can, as the harasser, know that you are in fact harassing somebody.
Right. And am I right, Alison, in saying it's somewhat similar, just the point that you were making, to what we've long discussed, for example, in terms of South Africa's rape culture and sexual violence more broadly, where even if there is consent from the victim, the accuser, they are allowed to withdraw consent at any point in the interaction?
Absolutely. I think that's absolutely foundational. And I think what we also have to know is that, and I think maybe the evidence will go there, but what can look like somebody freezing, perhaps, or we know in terms of fight and flight response that we have to look at freezing as well. We have to look at not answering, that these are normal responses under stress, and that may well have been something that was happening in the situation. But I'll imagine we might get more into that in the evidence tomorrow.
And do you think at the end of this, whichever way the tribunal will rule, that the outcome will ultimately have wide-reaching implications for the broader legal fraternity, especially how judges and their subordinates, for instance, relate?
I think it will, and I think programs like this are really important in allowing people to have the conversation about what sexual harassment does look like in the real world. And I think we are going to see that conversation carrying on in workplaces. I know the Sexual Harassment Code of Conduct is nearly finished, and I think that's something the Chief Justice is working to finalise, and that will also have an impact. So I think the ripples from this we'll see those over years to come, frankly.
Alison Tilley, good to talk to you. Alison is with Judges Matter, joining us on The Full View this evening. Thank you for your time as always.